Okay, at this particular time, if we have anyone that would like to address the board on public comments, you may do so at this time. If there's something that's on the agenda, you may do so at the time that is presented on the calendar. Okay, see no one up there, we'll go on beyond that. And we have an item number 2.1, the second reading of the August 26th Board of Trustees special meeting. So we have discussions on the second reading. The proposed policy revisions were 3430, sexual harassment, 3435, discrimination and harassment investigations, 3540, sexual and other assaults on campus, and 5500, standards of student conduct. In addition, an existing YCC Board Policy 2410 states procedures may be revised as deemed necessary by the chancellors and do not require board action. Accompanying the policies are procedure changes that are being provided to the board as an information item. The proposed administrative procedure revisions are 3430, sexual harassment, 3435, discrimination and harassment investigations, and 3540, sexual and other assaults on campus. 5500, standards of conduct of student conduct. So we have all the attachments. You have all received the attachments for this particular 4 items.
Taking all those at once.
You can.
I move that they be adopted as presented.
Second.
Been moved by trustee Viss, seconded by trustee Martin, that we accept the board policy second readings as presented. All in favor, signify by...
I'd like to have some discussion, Chair. I mean, isn't that appropriate?
Yeah.
Okay.
Yes.
I spent a lot of time talking at the last meeting. I don't particularly plan to do that today, but I think it's important that we provide some amount of due process for all members of our community, the YCCD community. I'm aware that that the Dear Colleagues letter from the Office of Civil Rights requires more due process than we normally provide. But I would like to see that minimal level of due process provided by the Dear Colleagues letter be provided to all members of YCCD in regard to these 4 policies that we're reviewing.
Any other comments?
I'm a little confused here. Were we entering into discussion at this point of each of these items?
This is the second reading, but you can address
Oh,
that.
that's what we're here for, and I'm sorry we didn't.
Yeah, that's all right. The explanation is better than no explanation, so, yeah, we have had the first reading on all of these, and then this is the second reading. And any other comments?
Are we going to have public comment?
I thought I'm sorry, I misunderstood. I thought you didn't want to comment.
Oh, no, we're here to do that.
Okay.
The 3 of us would like to speak to it.
All right. You're welcome.
Hi, Board. I'm Mike Adams. I'm sure you're familiar with me. I serve as the Senate representative on the Policies and Procedures Committee that advanced these drafts to the Board. And one thing that, from the Senate point of view, we're very concerned about is the idea of the process that was used to produce these drafts. That the feedback that was brought by the constituent groups was not what the board policy calls effective participation. Participatory governance at our district has this definition that uses the term effective participation, and it's really not possible to have effective participation when you arrive at a meeting with comments and objections and statements from your lawyers, and you're told that the decision's already been made, that the draft that will go to the board was already decided upon by the board before your constituent review is allowed to happen. That's a rather large problem. We're quite disturbed by that. And we hope the board puts a pause and allows our objections to have some effect so that it's effective participation. That's your own policy. If we wanted to get into particulars, we would have time to do that. But right now, with this rush to approve, I feel as if there's no time for us to actually address individual items. Especially since this meeting, I seriously had to run over here from Institute Day activities that there was no way to get here any sooner than I did. Having this meeting in the afternoon of Institute Day makes it almost impossible for faculty participation to occur. And the great rush that's being made, I really hope the board takes time to pause and get more communication happening now, because there's going to be communication happening one way or the other. The communication between the groups will either happen before the policy is created or will happen after the policy is created. At that point, the Senate won't have a role anymore. At that point, it'll be the union. But that's really unpleasant and costly, and I hope we can do that before that happens. So I wanted to make sure I had a chance to share that with you.
Thank you, Mike. Would you like to address the board? Thank you.
Just to follow up a little bit on process.
Can you
before
give
we-
us your name for the record,
Oh, I'm
please?
sorry, Alan
Sorry.
McKissick. I'm the YFA representative to the Policies and Procedures Committee. I'm also a senator at large in the Academic Senate.
Thank you.
I'm a faculty member in the Communication Studies Department. Thank you again. I was able to speak to this during the first reading. I want to follow up with some response to the responses that I heard to what we had to say. A couple more words on process. I described last time how the original draft of 3435 was so problematic that the committee agreed we really couldn't work with it very much because it was confusing. What part applied to students, what part applied to faculty, et cetera, et cetera. And after waiting for maybe a district revision, the YFA sent in, with consultation with the Senate, its own revision with changes we'd like to see. When it went to the meeting, there was no extensive discussion. Instead, it was sent to the district for the district's response, which is fair enough. That was in March. And then the district's response came in the form of another draft. No particular responses to what we had to say, but in another draft, which I understand is the state template, on June 6th. And we began that meeting by being told, this may not be changed. As a matter of fact, I'll quote, this is our new policy. This will be our new policy. Now, I'm really confused about the process here. It certainly isn't what is described on the website. So another word about process, please. You know, we've repeatedly asked that legal positions, which when we've taken them, we've cited chapter and verse and had a letter from an attorney saying these are the laws, statute, case study, and so on, the case citations. We haven't received that. Whenever we've been told this is the law, there is no choice, we have not received that kind of documentation or explanation. And we were given a copy of the PowerPoint that was shown to the board in its workshop on this very issue, right? And the PowerPoint simply said, for example, I'll bring this up in a moment, who is a responsible employee? You know that applies to several of these. All employees are responsible employees. No explanation. Now, maybe you were given additional explanation, but we haven't seen it. We'd love to respond to it, right? Again, no faculty member is saying we should not be in compliance. That's not the issue. And Mike already addressed the fact at the time of this meeting, it may have been necessary, I understand, but it makes it a bit difficult. You know, one reason President Jim Solomon could not be here, or Curtis Senate. All right, some particulars. On 3430, prohibition of harassment, we might as well talk about responsible employee a bit more. And what Title IX requires, as I read it, is for incidents of gender discrimination, sexual harassment, well, more specifically sexual violence, all that responsible employees must report, right? Now, well, excuse me, that is not what I read, excuse me. That's not the point. That is the interpretation we're hearing here. I'm going to read you a couple things really briefly here. This is from the United States Department of Education Office for Civil Rights, dated April 29, 2014. The definition of responsible employee includes several categories, and anybody to whom whom a student could reasonably believe has authority or duty. Reasonably believe. A school must make clear to all its employees and students which staff members are responsible employees so that students can make informed decisions about whether to disclose information to these employees. Now listen to the way that's worded. A student may want to talk to someone and want to know if that person is compelled then to report it elsewhere or to start a process or not, right? Now, then it says down here, whether an employee is a responsible employee will vary depending on factors such as the age and education level of the student, the type of position held by the employee, and consideration of both formal and informal school practices and procedures. And I quote, for example, while it may be reasonable for an elementary school student to believe that custodial staff member or cafeteria worker has the authority or responsibility to address student misconduct, it is less reasonable for a college student to believe that a custodial staff member or dining hall employee has the same authority. But as you know, in these policies it says that all employees are responsible employees, and furthermore, the board has been told that's legally required. Well, this is confusing. Our attorneys advised us otherwise. And then I'm reading to you again from the United States Department of Education Office for Civil Rights. Okay? I'll provide this to you if you wish. Now, moving down to what's the impact of this? No one is suggesting that something egregious shouldn't be reported. That's not it. But again, the wording in the government document itself suggests that a student may be in a position of wanting to talk to somebody without that person being compelled to report it higher up, right? Okay, moving on. Let's talk about 3435 and several of the items we brought up last time. Now, on a number of them, we were told there was a legal dispute or legal disagreement about what's legal or not. As I said last time, that left about half of the points we made about 3435 in another category because they weren't about legal disputes. And I want to speak to the responses we heard that evening. All right, this one is key. The respondent should receive the complaint or a detailed summary of the complaint at the outset of the investigation before the respondent's interview, which includes specific reference to what policies were allegedly violated. Now, to quote what I said last time, this is simply the most basic fairness and also essential to good fact-finding because the accused can bring relevant evidence, email schedules, instead of being blindsided. Some non-faculty representatives on the Policies and Procedures Committee were incredulous that it was not in the draft of 3435. I remember them leafing through trying to find it that we were working on, and when they could not find it, insisted it must be elsewhere, which is apparently not so. The committee quickly and unanimously agreed that this provision should be included. We agreed in committee for this, and it's nowhere to be found in the current drafts. Now, we did hear, well, wait a minute. This relates to something negotiable. A lot of 3435 and the others relate to something negotiable. They overlap. It's unavoidable. And there's nothing inappropriate about what you're doing today, talking about these policies, of course. Another point, the wording of Article 39, which was referenced, is extremely vague, and that's for YFA contract, and it just says the accused will be given a quote, summary sufficient to put the faculty member on notice of the nature and scope of the complaint. That's the most specific wording we could get after hard bargaining. It is not adequate. A couple of more things about this. Number one, this only covers full-time tenure faculty. It does not cover a great deal of our faculty. The adjunct faculty are specifically excluded here. They're not covered, even by this very vague protection. Furthermore, remember 3435 covers all employees, not just union members. Not just union members. So to suggest that the YFA's contract, Article 39, and please read it, somehow makes this, this amendment unnecessary is absurd. Second item. One other thing we said is that in addition to union representation, the respondent has a right to the presence of an attorney during proceedings. The response I heard was, well, you have a right to an advisor, just make the advisor an attorney. We already referenced that. We know we have a right to an advisor, right? what we talked about was you could have your advisor there and an attorney. An employee in a union, employees in unions have additional rights, and an experienced advisor from the union may be essential, and the person has a right to an attorney. Now, just simply spelling this out, as opposed to having problems, seems reasonable. Okay, another item. Scheduling of interviews, meetings, and so on should reasonably accommodate class schedules of respondents and advisors. And the response was, Article 39 covers that. Please look at Article 39. It does no such thing. It's not there. It's simply not there. Now, when you think about adjunct professors who are likely to have their professional life even more disrupted and their services to students even more disrupted, it becomes a bigger problem. And once again, they're not even covered by anything in Article 39. Now,
Excuse me, what do you mean by disrupted?
oh, if you are called in for an interview and so on, and it's not scheduled with some kind of reasonable accommodation to when you teach. All we were asking for here is that there be a reasonable accommodation of class schedules of respondents and advisors. You might be called in, and I've seen it happen, by the way, where it says, the meeting's on Monday at this time. And that's it. As opposed to, can we work with that because of a class schedule? Right? Now, another thing we brought up, the respondents' advisors must be permitted to be active participants in the interview. The district, now think about the advisor being there. Why? Just a watchdog, right? A member of the public or something? The advisor's there to advise. If the advisor can only advise before the meeting, then why come into the meeting at all? The district response was that the advisor is not allowed to interfere. We know that. We acknowledge that. As a matter of fact, no one has a right to interfere with this process. No one. Now, union members' Weingarten rights in this area, and when you look at it, it includes the right to ask questions, right, to elicit facts, to make comment on procedure, includes all kinds of specific rights. These have been violated. We'd like to see it right in policy. What can an advisor do or not? Simply saying you have a right to an advisor that's there without specifying and may participate. If you want to be specific about how and how not, fine. That would be an improvement. But remember, 3435 is not just about union members. What about all these other people? Now, we referenced the preponderance of evidence standard, which I know is required in Title IX. And we brought up how weak a standard it is, just more likely than not. It's a very weak standard, for any kind of justice or determination of truth. The response we got, well, here's what we advocated specifically, that where that's required, preponderance of evidence, for instance, Title IX issues, by all means, we must comply. It's required by law. Anywhere else it's required by law, fine. But we said, where it's not required by law, please use a more reasonable standard, which is the clear and convincing evidence standard. And the response we got was, Title IX requires it. Excuse me, I think you heard what I just said. Where it's not required is what we're talking about. Now, these policies are not just about the kind of harassment and discrimination covered in Title IX. It's about age, ethnicity, religiosity, or the lack thereof, all kinds of things. All right? Now, about records, when there's no record of wrongdoing, when there's no finding of wrongdoing being destroyed after a certain amount of time, I did hear the district's attorney say, well, you can't do that, it's public records. Well, it's really ironic because at the last Policies and Procedures meeting, I think it was last week, we actually looked at the first draft of a policy about destroying records at this college. And it made a reference, I haven't had time to study, to the Ed Code, which says there's a certain class of records you're supposed to destroy, a certain class you're not supposed to destroy, a certain class where it's optional, or you could put down time limits, we'll keep it for 90 days, then destroy it. I'm very confused, and I don't believe the blanket statement about no destroying public records is true. We should look further into this. Again, we're not talking about all records, we're just talking about when there's no finding of wrongdoing, after a certain number of years, destroy the records before they cause a problem. Right? Now, I'll jump down to 3540. This is something we didn't really address last time. And again, just like I said last time, 3435 seems to be the most important issue. But about 3540, several things. One, preponderance of evidence standard. We've talked about that. Supervisory, who are responsible employees? I've addressed that. But when you look at it, it's kind of interesting. It says that power differential personal relationships, say between employee supervisor, power differential personal relationships conducted outside the workplace are, quote, discouraged. They are not prohibited. It specifically says they're not prohibited, but they're discouraged. Now, how exactly is this supposed to be implemented? Who's supposed to do the discouraging and how? Does someone read this to people so they feel discouraged? What if a supervisor feels, well, it's discouraged, I need to do something about it? What is to be done? Calling someone on the carpet and discouraging them? And furthermore, policy and procedure require that power differential personal relationships, specifically not prohibited, must be reported to a supervisor. At what point do you report it's a relationship? I mean, really? And then what? Does the discouragement take place? Is this apology when you just say it's discouraged? It doesn't even seem like policy to me. And furthermore, I can quote you chapter and verse. We're informed that California doesn't allow non-fraternization policies, which this is. And furthermore, people have privacy rights, which this violates. Now, we're talking about conduct away from the workplace and this vague language about discouragement, and then being told, depending on your definition, you got to go talk to your supervisor at some point about it, right? So I would be glad to answer any questions about any of these items.
No questions? Thank you.
Thank you.
Well,
I think Sarah wants to go. Mhm.
Hi, everybody. Alan asked me to come in and speak to you. I'm the YFA Vice President and Grievance Officer, and I've participated in, I tried to make a count before I came in here, and I've participated in 13 investigative interviews since 2013 when I started this job. And he asked me just to speak to you of some of the specific things that have happened that lead to some of these concerns that we have. And I really I narrowed it down to 3 different things, wanting to take up too much of your time.
All right.
I'm sorry?
I said, no, that's all right.
Oh, okay. One of them is the summary of the complaint issue. As Alan mentioned, the information or the statement in Article 39 is very vague. It just calls for a statement of the nature and scope of the complaint and the approximate date. And in addition to the fact that this does make it more difficult for people to prepare, there have been a couple of situations in which, I think that this would have improved things in other ways also. We did have a situation where there was a complaint of one faculty against 2 other faculty members, and we were not given information about the nature of the complaint, but it turned out that the complaints were mostly along the lines of things like, he didn't say hi to me when he went past me in the hall. And he wants to schedule meetings through email rather than meeting in person. None of these complaints would really rise to the level of a disciplinary action. And as it happened, we ended up in meetings. I think they were a couple of hours each. For the 2 faculty members, there was one that was a witness and one that was complained against. It took up, I have to accompany them when they go into these complaints, so it took up a whole lot of time that I felt was unnecessary, and it cost the district's money. When we hire a private investigator, it costs money, and I think that had we had a little bit more information about where this was going, we might have been able to work it out at a less formal level. There was a second incident that happened in which the only information that the district was given was a citation of the Ed code, and I don't remember the number, but it's the citation of Ed code that gives grounds for dismissal. So it has things like incompetence, or moral turpitude. These are extremely vague, broad categories. And the district requested, we started trying to get more information to, narrow things down. And as we did, it turns out that the investigation was completely dropped because it just was not serious enough in nature to warrant moving ahead with it. So I think that it's good for not only the faculty, but the district to have a little bit more open communication about these things, just so that we don't end up wasting the district's money on something that shouldn't be investigated, and also taking time away from faculty who should be devoting it to their students. That's really, what we're all supposed to be focusing on primarily. So that was one thing I just wanted to tell you guys about. The second one was about tape recording. I don't even know if this is on the table anymore, but we did have a situation when I first started this job in 2013. Our policy, our YFA attorneys have always advised us not to allow tape recording, and the district was complying with that. So we would go into the room for the investigation, and the investigator would always say, well, I'm going to tape record you if that's okay, and we would always say, no, we're sorry, that's not something that we do here. At one point, we went into an investigation, and without warning us in advance, the district decided that, we are going to tape record you. And our attorney, the YFA attorney, has always advised me, if that happens, to please call him and, get his advice on how to proceed. So as it turned out, there was a long delay while we waited for the attorneys to get back to us, and when he finally got back to us, we were informed that, we have to comply. And this was done, the faculty were required to comply, but it was under threat of dismissal. And this was that same investigation where the allegations were so ridiculous that, there's no way that there was going to end up being any discipline for them. So it was a terrible experience for these faculty members who are really good guys and very pro-district people. I felt like if there was a way that the district wanted to turn people away from them and make them feel unvalued, that was probably the quickest way to do something like that. So so that was a really unpleasant process. And then the third one that I just wanted to address was about the scheduling of interviews. Again, there's been a past practice at the district of recognizing that faculty have very tight schedules, and when you're trying to schedule 2 faculty at the same time, so it would be the person that's being investigated plus me, or whoever it is that is their representative, that can be kind of difficult. It's surprising, but we are in a lot of meetings, we're in class. At one point, within the last year, I believe, we were simply informed that the interviews are going to be scheduled, and if you can make it, that's great. Otherwise, too bad. So I really felt like when Alan and I have been discussing some of the things that need to happen, I really felt like that is an extremely important issue. You cannot have just anybody go into the room because, as I've found out, the more of these interviews you go through, the more knowledgeable you become. So you really want to have faculty represented by the best person that's available. And sometimes that means that it can't be done tomorrow, it can't be done in 2 more days, that maybe it will take a little bit more time than that to schedule things.
Any questions?
Did you have any questions?
Well, I just have a question sort of for all of you. These concerns, do I understand correctly, were all brought up when you were going over the policies and procedures, and none of these concerns were compromised on to reach agreement? Is that correct? You were just told this is the way it's going to be?
Can I let Alan take over for me now?
I think to be fair, at the June 6th meeting, it was the first time none of these issues were discussed. But they were discussed, each one of them. And even the ones that were agreed to in prior meetings, once there was, I think there was agreement, this is reasonable. Some, there was strong disagreement. Some, I think there could have been room for compromise or some creativity, right? Span that, right? But even the ones that we had tried to agree to, the answer to, at the end of the discussion, was objection noted. So it wouldn't be fair to say there was no discussion of these issues, but some of the discussion didn't, some of them didn't really occur to June 6th because of that discrepancy.
I think Connie had her hand
Yeah,
up.
Connie,
Just
no
speaking
further
of
questions
the
for the
process,
speakers.
Thank you, Alan, for noting that. Just
Yeah,
speaking of the process, you know, what we had to come to a place of is we could not make changes that were not in compliance with the law. And we were being counseled on what the law was in these things, specifically tape recording and such and so on. So to honor the process and really to bend over backwards and say, you know what, I hear you guys and I want to bring this forward. I can't make any changes to these things because it's not in compliance with the law, according to what our legal counsel is saying. But I am happy to bring your objections forward to the board. We've come to an impasse where your attorney believes one way, the attorney for the district believes another way, and really, I'm not the decision maker on this, the board is. So, yeah, we did get to a place where we had to just say, can't make changes that are not in compliance with the law.
Do you recall when he, if I heard correctly, and correct me if I don't remember, that you said you talked about the committee prior to June 6th, that you talked about that when a person is accused of something, you know, I'm on the due process part, that it was agreed by everyone that the person who is accused will get a copy of what they're accused of or information specifically and knowing what policy that they've violated. That was agreed to by everyone. Connie, can you speak to that?
You know, there were a number of drafts that came forward. The faculty did bring forward a draft that they were very interested in. Unfortunately, that draft did not include the student component and so on. So we weren't able to use the draft that the district first put together, and we weren't able to use the draft that the faculty put together. So we went to the CCLC template. As far as that specific issue, I cannot remember where we were, but I know that in the policy committee, we don't agree to anything that's not in compliance with the law. And, you know, I'm very clear and careful with my words. And so before I go further on things like that, we get legal counsel advice.
All right, thank you, Connie. You know, I appreciate all your comments, and I think as in any policy that we try to address, we try to do what we think is best and within the law. There's no perfect policy. There's no perfect Constitution of the United States. Or, you know, I've been around quite a few times, and everybody's always challenging something, and so it's difficult to come up with a perfect solution. And it's my hopes that that whatever decision we make is that it's in the best interest of the district and students. I mean, we're trying to protect students. Sometimes I feel like a parent, you know. We raise our kids and we try to do the best we can, but they do, you know, stray every once in a while. And we want to protect those students. And as far as I'm concerned, that's my main concern, is protecting students. And I'm hopeful that if we do adopt this policy as it is, that it will be in the best interest of the district and the students and faculty. And I think some of the issues that you address, I think once the policy is passed, that they can be, I don't know, compromised in a sense of of when to meet and when not to meet. You know, if that's really a big issue, I mean, that shouldn't be. I mean, but that's just me. Yes, sir.
Could I address the board, please?
Sure, come on up.
Okay. I really don't want to address the board, but because I wish I had a better speaker for myself, and these people have done a good job. My name is Bill Hawley. I am the YFA representative for adjunct faculty. It's about 400 souls. We don't make a lot of money. We work without benefits. We have no right to be, we're peace workers. We can be dismissed at any time. We are, as our chancellor referred to me as, I'm an at-will employee. That means I can be dismissed at any time without reason. I think it takes a vote of the board to do that. But anyhow, what I want to say about this is Chairman Abe says that he wants to, he's doing this to protect students and faculty. It seems to me that the most basic protection and the most basic kind of respect and value that you can convey to the faculty and the students is to let them know that if they're going to be charged with something that can result in their termination, their job determination, or their dismissal or expulsion, that they at least have the right that's been accorded to citizens of the United States and to other people too. Anybody who lives within our jurisdiction has this protection, that if they're charged with something that's serious by an arm of the state, that they are being told up front what it is they're accused of doing. We get this on even on TV. When the officer says, gives you problems, you say, am I under arrest? What's the charges? But this district has been in the habit of, and these rules allow them to pursue investigations against people, faculty members, students, and other people like that, other members of the community, pursue investigations and tell them that they're under investigation. And when you ask, when these people are asked, what the heck am I charged with? What's the policy? What did I do? They say things like, well, we can't tell you. It took them 2.5 months to say, well, in my case, when 2 people filed complaints against me, I was told, well, it's something under the harassment, discrimination thing. So I finally located it. Gina Liguria refused to, she just couldn't tell me what, because they couldn't tell. Apparently the person that was making the complaints, the people that were making complaints against me had potatoes in their mouth. Or they were inarticulate, or they couldn't write. I don't know why they couldn't tell me what the complaints were, but those harassment things, all I had done in my complaint was I had accused people of breaking the law. I have accused people of crimes. But to satisfy it under a harassment complaint, it has to be, you have to harass somebody on the basis of their protected status, gender, something like that. And so I think that ought to be in there too. If you use the state chancellor's form that you're supposed to use under 3435, Gina, do you have those forms in your office? The chancellor's forms for the harassment claims?
I sent them to you, so you know that.
No, you didn't send them to me.
I sent you the link.
No, not the state chancellors. I had to get those from them. But anyhow, it has boxes that you have to check. Okay, but anyhow, what I'm saying is that the basic protections that people as Americans have is that they're told what the charges are, what they're accused of doing, what they allegedly did, what policy they violated, and at the end of all that, they ought to at least be told what the results were. You know, if you're tried by something, you get a verdict in the end. Guilty, not guilty.